Alternative Dispute Resolution (ADR), known in some countries, such as India, as external dispute resolution, includes dispute resolution processes and techniques that act as a means for disagreeing parties to come to an agreement short of litigation. It is a collective term for the ways that parties can settle disputes, with or without the help of a third party. Despite historic resistance to ADR by many popular parties and their advocates, ADR has gained widespread acceptance among both the general public and the legal profession in recent years. In fact, some courts now require some parties to resort to ADR of some type, usually mediation, before permitting the parties' cases to be tried. Indeed, the European Mediation Directive 2008 expressly contemplates so-called compulsory mediation. This means that attendance is compulsory, not that settlement must be reached through mediation. Additionally, parties to merger and acquisition transactions are increasingly turning to ADR to resolve post-acquisition disputes. The rising popularity of ADR can be explained by the increasing caseload of traditional courts, the perception that ADR imposes fewer costs than litigation, a preference for confidentiality, and the desire of some parties to have greater control over the selection of the individual or individuals who will decide their dispute. Some of the senior judiciary in certain jurisdictions, of which England and Wales is one, are strongly in favor of this ADR use of mediation to settle disputes. Alternative dispute resolution (ADR) is generally classified into at least 4 types: negotiation, mediation, collaborative law, and arbitration. Sometimes a 5th type, conciliation, is included as well, but for present purposes it can be regarded as a form of mediation. See conciliation for further details. ADR can be used alongside existing legal systems such as Sharia courts within common law jurisdictions such as the UK. ADR traditions vary somewhat by country and culture. There are significant common elements which justify a main topic, and each country or region's difference should be delegated to subpages. ADR is of 2 historic types. First, methods for resolving disputes outside of the official judicial mechanisms. Second, informal methods attached to or pendant to official judicial mechanisms. There are in addition freestanding and/or independent methods, such as mediation programs and ombuds offices within organizations. The methods are similar, whether or not they are pendant, and generally use similar tool or skill sets, which are basically subsets of the skills of negotiation. ADR includes informal tribunals, informal mediative processes, formal tribunals and formal mediative processes. The classic formal tribunal forms of ADR are arbitration, both binding and advisory or non-binding, and private judges, either sitting alone, on panels or over summary jury trials. The classic formal mediative process is referral for mediation before a court-appointed mediator or mediation panel. Structured transformative mediation as used by the U.S. Postal Service is a formal process. Classic informal methods include social processes, referrals to non-formal authorities such as a respected member of a trade or social group, and intercession. The major differences between formal and informal processes are A. Pendency to a court procedure and B. The possession or lack of a formal structure for the application of the procedure. For example, freeform negotiation is merely the use of the tools without any process. Negotiation within a labor arbitration setting is the use of the tools within a highly formalized and controlled setting. Calling upon an organizational ombudsman's office is never, by itself, a formal procedure. Calling upon an organizational ombudsman is always voluntary. By the International Ombudsman Association's standards of practice, no one can be compelled to use an ombuds office. Organizational ombuds offices refer people to all conflict management options in the organization, formal and informal, rights-based and interest-based. But, in addition, in part because they have no decision-making authority, ombuds offices can, themselves, offer a wide spectrum of informal options,